All right. So this is the topic, acceptance. From the word accept, obviously. So this is the second, we call it ingredient, or the second essential to a valid agreement. So this is the second stage, or if you want to start with negotiations, then this is perhaps the third stage. Okay, negotiation will include invitation to trade as well. Okay, preliminary to an offer, and we have discussed thoroughly what are the requirements for a valid offer. Okay, and now we have come to the next stage or next phase in order to come up with a valid enforceable agreement or contract, which is acceptance. So what is meant by acceptance? Okay, to know is always to love. So we need to know, okay, we need to be able to explain or express, okay, say expressly what amounts to an acceptance, which is recognized by law. So we have many styles or many ways, many variations of definition here, but they share the same keywords here. As you can see that I have underlined, okay, the word is assent. Okay, the first definition, okay, a final expression of assent, okay, to the what? To the terms of proposal. Assent of what? Assent means approve or you agree. Agree to what? Agree to the terms of a proposal. So there must be a proposal at the first place, okay? Then only it can be followed by acceptance or assent. We call it expression of assent. Or another way of defining the word acceptance is that an unconditional assent. It has to be unconditional. Okay, an unconditional assent communicated. So it has to be communicated by the offeree to the offeror. Because if proposal from offeror to the offeree, now communication is from the offeree to the offeror. For what? To all the terms of the offer. Okay. And then it is made by the offeree with the intention of accepting. Because lack of intention, it might lead to the inference of no contract yet formed between the parties. As you read in the case that I have given you, so you can see one of the cases is about negotiation. So that's an example, okay, of what happened between the parties. Even though maybe one of them is trying to argue, oh, there was contract, but then when the court look further, look deeper, examine all the facts, actually there's no contract yet. They are all about negotiations. Okay, the last one we take it from one of the textbook. And he's the author, and he's also, I think he was the judge. Okay, Visu Sinadura. So he proposed this definition. He introduced or he creates this definition. He said that the exercise of the power, okay, by the person to whom the offer has been made. So in shorter word, exercise of the power by the offeree. Okay, to do what? To enter into a contract. By what method? By manifesting, by showing, by demonstrating of what? Assent. Again, that's the keyword, assent in return. Meaning that here this is on the part of the offeree. Okay, and this is in response, in return of the offer, which has been communicated to the offeree by the offeror. Okay, we have one latecomer. I need to. Okay, Hambaima just join us. Okay, welcome to the class. Next time, try to be punctual. I always have problem to go back to the slides. Okay, here, this is my slide. Right. So we were here, so we are done. Okay, we want to have a look at section 2B, which is the interpretation. Okay, or we call it statutory definition of the word offer. Okay, section 2B. I think last time we were at section 2A. Now we want to have a quick look on section 2B. Okay, where is it? Okay, here, okay, interpretation 2B. When the person to whom the proposal is made signifies, okay, indicates his assent, that's the word assent there too, the proposal is said to be accepted. Actually, B is in connection to A, meaning A, B comes after A, okay, interpretation to A and then followed by 2B. The proposal is said to be accepted. A proposal, when accepted, becomes a promise. A promise here is actually refers to a contract or an agreement. Okay, I mean here a promise is another word to to explain or to express the term contract or an offer. Okay, we go back to our slide. Okay, that's section 2B. And then now we go to the requisites. Okay, what are the requisites or requirements of a valid acceptance? We have section 7A, clause A, Contracts Act, which is very, very expressly made, okay, provided here, express provision 7. 7A. It has B as well, but we want to focus on A first. Here, acceptance, okay, the word is must. It has to be no other choice, no other option. Acceptance must be absolute. Okay, so here it says here, in order to convert a proposal into a promise, the acceptance must A, be absolute and unqualified. Okay, if it's not, if it does not fulfill this requirement, then it remains as a proposal. I mean, it cannot be converted into a promise. It doesn't reach the stage of promise or contract. Basically, it remains as a proposal or an offer. Okay, we go back to our slide. Okay, and then another requirement is that, okay, must be absolute and unqualified here. So the further explanation about this requirement is that what it means is that acceptance, okay, we are talking about requisites of a valid acceptance. So acceptance must correspond, another word is must tally, okay, with the exact terms proposed by the offeror in his offer, or this is known as the mirror image rule. So if you're standing in front of a mirror, okay, you can see exactly, okay, the real image, okay, in the the reflection, okay, in the mirror, exactly, is exact thing basically, no changes, nothing. So it has to correspond. If the proposal contain terms A, B, C, then the acceptance, the acceptance must contain also A, B, and C. Cannot contain A, B, C, and D, or cannot contain A and B only. All right, so it has to correspond. That's the word. Okay, let's have a look at the case. Okay, this is actually to explain this rule, must correspond. So basically here, it's not, it does not correspond. The case is Lau Karyit and others, and Muhammad Isa and another, 1963. It is pertaining to option to purchase a land. What's the meaning of the word option to purchase here? Usually it refers to specific legal agreement. The parties agreed, okay, usually the proposer or the offerer, okay, agrees to give certain time, okay, for the offeree, okay, to accept. Okay, meaning here within a week, then you have to let me know. Okay, option for you to buy, option to purchase basically, and sometimes there must be certain payment. Okay, that's why we use specifically the word option to purchase. So a land, and then this option actually was made, it contained subject to a formal contract, okay, to be drawn up and agreed upon by the parties. Here the parties end this debate, okay, there must be a formal contract, okay, to be drawn up later, and both of them agreed with this arrangement. And later they have dispute to see whether there's a contract or not between them. Okay, the court held that agreement to enter into an agreement is not a contract, because why? It is made conditional. It is not unqualified. This is what we call as it is qualified. It is not absolute. So the exercise of the option, okay, if the offeree take up, okay, whatever terms in the option, okay, exercise of the option, it amounted to nothing more than agreement to enter into an agreement, which has no legal effect at that point of time, at that particular stage. No enforceable contract yet, until and unless, okay, they settle or they completed the drafting of the agreement, okay, drawn up and agreed by the parties. So basically this case explain, okay, the rule just now, okay, here, okay, in which acceptance or whatever agreement between them, it wasn't made absolute and unqualified, it was qualified. And then another rule is that remember, acceptance has to be unconditional. So an unconditional acceptance, okay, of a tender. Remember, tender is offer, okay, a type of offer. So if it involves unconditional acceptance, okay, of a tender, so whether we have a contract, yes, okay, it forms a contract and it binds both parties. This is what happened in the case of Cheng Keng Hong and Government of Federation of Malaya, 1966. Here, government issued a notice inviting tenders to construct certain school. An applicant actually submitted his tender for the work, and he was successful. Okay, he managed to get the tender, and they signed a contract. So that's the normal process. But the problem is that actually there was this discrepancy. Okay, when the applicant prepared all the tender document here, okay, he is supposed to put in everything, incorporated everything, all the terms here. And then the government actually has given acceptance. Okay, and so here unqualified tender in the expectation. So basically the applicant here actually miss out certain point. Okay, miss out certain expenses or claim. Okay, he didn't actually incorporate everything here. Okay, because he thought he would be paid extra for the electrical work shown in the drawing but not mentioned in specification. So whatever things he attached together with the document, the agreement here, he doesn't say clearly the extra cost to be claimed for electrical fitting. He thought he can claim it later. Okay, and actually there was communication afterwards. Okay, by chief architect. Who agreed, okay, we'll pay you later, extra. All right, but later some other parties in the government said, no, we are not going to pay you because we just focus or we just rely on the agreement that we have signed. Nothing extra payment whatsoever. Yeah, and this is the court's observation. The court said that the law with regards to acceptance of a tender is perfectly clear. And if it is a conditional acceptance, then it is. It binds both parties. Nothing extra after that. If you want to put specification or terms, whatever term, it has to be there. It has to be incorporated into the agreement here. All right. So the court actually limit the application of the tender here to all documents forming the tender and acceptance, and it didn't include the payment for electrical fittings because applicant thought he can get this extra payment. The drawing is there, but there's no specification, there's no cost whatsoever for this electrical fitting. So too bad, whatever which is beyond the thing that they have signed, so it is not part of the agreement between the parties here. Between the one who propose, between the one who accept, government is the one who accept the tender submitted by the applicant. You can have a look at the actual wordings of the judgment here. Okay, another another issue. What if an acceptance is not absolute? We know the rules that it has to be absolute. But what if the acceptance is not absolute? What happened? What is the status? What's the position? Basically, in that particular situation, the acceptance actually will amount to counter offer. Meaning here the parties change roles. So it kills the offer. It kills the first one. It terminates. It puts an end to the first one. It's possible for the offeror to be the offeree later. Because why? The moment there is a counter offer by the offeree, now the one who proposed the new offer, the counter offer becomes the offeror with the new terms, obviously. We discussed the case of Hart and Wrench in our previous lecture. You can refer to slide number 3 later for the topic offer part 3. Last week we discussed it. We don't want to repeat the case again. We don't want to repeat the case. You can have a look. We are discussing this case. A very old case. This is common law. Jones and Daniel, 1894. So here A offered this amount, 1,450 pounds for a property belonging to B. And then in accepting the offer, B is the one who is supposed to accept. B enclosed with the letter of acceptance, meaning yes, I accepted for the signature of A. But then he actually included new terms, various terms. He was so detailed with it, whereas they didn't actually discuss about it. It wasn't the term proposed by A. So this document contained various terms as the payment of deposit, date of completion, all fundamental to the agreement actually. Date of completion, requirement of the title, which had never been suggested in the offer. So now as if B is the one who proposed rather than A. All right, so when the case was brought to the court, the court held that there was no contract, basically. Because why? When here, when they change position here, A actually was not agreeable to the new terms proposed by B here. But B said there was contract between them. Okay, that's why they brought the case to the court. The court said that there was no contract because why? B had not accepted his offer. He's supposed to accept, okay, without any condition attached to it. But he proposed some other terms, okay? So he made a counter offer of his own. And then A never accept his counter offer. Okay, so which was never accepted by it. So there was no agreement. There was an offer because by way of counter offer by B towards A, but there was no acceptance by A. Okay, B is supposed to accept, but he didn't accept. Actually, he proposed new things. So he is now the offerer, the proposer, the one who proposed. Okay, is it possible to accept by acts or omission? Okay, mean that here you don't say I accept whatsoever, but then you just perform. Of course it is. Okay, yes, the answer is yes. So an offerer may, mean that the option is that it's possible to happen, may invite acceptance by an act or conduct. So in that situation, okay, requirement that acceptance must be communicated to the offerer may be waived. Because in normal situation, okay, acceptance has to be made known, okay, to the one who proposed it. But exceptionally, if it is by way of performance, no need to inform. Just perform, then is considered as acceptance already. Remember we discussed about the case of Kalal. Okay, we also discussed section 3, section 8. You can have a look later. Kalal, okay, advertisement in the newspaper. Whoever come and bought our medicine, carbolic smoke ball, okay, the smoke ball, and still caught flu, then yes, you are going to pay you. So anyone who went to buy and then use as per instruction and still caught flu, just go and claim. Because why? Whatever performance, okay, by way of action here, it amounts to acceptance already. No need to inform the company, hey, I accepted the offer. No need. Okay, this is only by way of performance, but only in exceptional situation. And we also discussed the case of Arrington. Okay, remember last week? So now you can actually later refer slides number 22 of part 3. We don't want to rediscuss the case again. And then, is it possible to accept by omission? Okay, if by act, then it's positive act, you do something. Is it possible if you accept but you don't do something? I mean, without doing anything by way of omission. Actually, we don't have any case law which is directly to discuss about this. But I mean, here it's not totally impossible. It might be possible. That's why here failure to reply may or may not amount to consent because there's no direct case on this, so it's not a real issue. And I think it's very unlikely, okay, for you to accept by way of omission. Usually it has to be something that you do, perform positively rather than you prevent yourself from doing. How do we know? Okay, it amounts to acceptance. So there could be some issues to prove this. Okay, we have the case of Fraser and Everett, also common law 1889. So in this case, the court held that in law, actually, there's no such a legal ruling saying that silence means consent. Okay, if you don't say anything, that's omission. Okay, if you don't say anything, if you don't do anything, so I take it as acceptance on your part. No, okay, the law won't recognize that. You cannot say silence means consent. Generally, yes, but legally speaking, no. It's hard to prove that. Okay. Especially when we talk about mercantile. Okay, mercantile would include contract law, okay, trade or commerce or commercial. Okay, it has to be something which is expressive, okay, which is clear, okay, and can be proved in the court later. Because if you just remain silent, how do we know that you consent? Or maybe you don't consent to it. We never know. Okay, so silence actually in law is not really a good evidence. Okay, it's not really convincing to say that, I mean, to indicate that you consent to it. So whenever I give you a task, okay, but if you don't ask, then I assume you understand and you accept and you have to do it, isn't it? But that's not mercantile. Okay, now we are discussing, this is another subtopic, manner of acceptance. How, okay, how to do it, okay? How do you, I mean, in what way it can be done, basically? How do you indicate to the other person that you want to accept, okay, the offer or the proposal? We have section 3 and section 7, subsection B, basically. This is the G's from these two sections. We have a quick look on the section 3 and section 7B. Okay, section 3. Section 3 talk about communication actually. Here, okay, generally, this is general provision because it covers communication of acceptance and revocation of proposal. Yeah, okay, acceptance of proposal, whatsoever. And then section 7. Okay, here 7B. Okay, just now we were discussing 7A. Now we move to 7B. In order to convert proposal into a promise, the acceptance must, okay, how to do it? Be expressed in some usual and reasonable manner. It has to be something which is reasonable, usually done, reasonably done, unless, okay, proposal prescribe, explain or indicate the manner in which it is to be accepted. So if there is prescribed manner, then the offeree has to follow. Okay, but if there's no prescribed manner, then the one who wants to give acceptance just just accept in the usual and reasonable manner, which is very, very subjective. Okay, which might create problems as usual. Alright. So prescribed manner, okay, of acceptance must be followed. Meaning that if the offerer say you must accept by way of telephone call, okay, let me know by calling me, let me know, okay, through telephone call. That's prescribed manner. So if the offeree choose to email, okay, so it won't be considered as prescribed manner, okay, because it has to be followed just now. But what if the offerer say, okay, you can accept my offer, and that's it. Please accept my offer by tomorrow. But there's no prescribed manner how to accept. Is it by way of oral or is it by way of email? Is it by way of WhatsApp? We never know. Okay. So if not prescribed, then the court will look at the usual and reasonable manner of acceptance. Usually, if the offer is by telephone call, usually you have to accept by telephone call as well, isn't it? So it depends on the situation. What is usual or reasonable in that particular situation at that point of time. Those days, okay, early century, okay, now we are 21st century, maybe 20th century, okay, the usual manner is by way of post, but nowadays, post is not really usual, okay. You have to say it clearly if you want to be accepted by post. Okay, so we go to the rule at common law first. So at common law, acceptance communicated by any other mode, okay, by any other methods or manner, which is no less advantageous, will conclude a contract. For example, okay, please accept my offer by email, okay, or maybe this is the current one. Okay, if the old mode, please accept my offer by way of post. You have to post the letter to me. But if the offeree, okay, chose to call is faster. No less advantageous, faster, speedier. So actually it can include a contract as well, even though the offeree yet to write a letter of acceptance. Okay, that's the rule at common law. So here, an acceptance requested by return of post may be made by telegram, which is faster those days, or even by verbal message, okay, which is like akin or similar to face-to-face. Rather than you post a letter, you wait for a few days, and only you receive the letter. So there's a gap of time. But if it is by telegram, usually within the same day, within few hours, or verbal message, it's like face-to-face lah. You say it clearly to the other party. You want to accept the offer. This is the rule at common law. So we have a look at the case here, very old case, Tin and Hoffman. Plaintiff wrote to defendant asking for a price, okay, of certain irons here, and defendant give the specific price, okay, make the offer at specific price here. And then when defendant made the offer, he asked for reply by return. By return here means return of post lah. It doesn't say, it's like short form. Okay, by return means return of post, those days, okay, those century. And then the court held that, okay, if the offeree was requested to reply by return of post actually, then any methods which would arrive no later than return of post would do. So let's say offeree said, oh, I want to make it faster, so I choose to use telegram rather than normal post, then it is valid, it is accepted, or even by verbal message. This is the rule at common law. But what is the rule in Malaysia? Okay, we have read section 3 just now. Section 3 is quite general and broad. But we also have Electronic Commerce Act 2006, which is very relevant. Okay, nowadays, most of the time we use electronic method, okay, to communicate, okay, for the transaction whenever it involves e-commerce, or even whenever nowadays we use internet, okay, we use whatever social media, for example, WhatsApp or Telegram or whatever platform that we use. So yes, this specific act or provision, okay, or statute, we call it statute, would be relevant. We call it ECA, okay, Electronic Commerce Act 2006. Actually, I reproduce to you a number of relevant provisions. So if you want to read the full act, you can have a look. But then this is some of the selected provision which is relevant for our discussion. The first one, it talk about section 7. It talk about formation and validity of contract. So I put in red font there. Okay, it may be expressed by electronic message. Meaning here, in terms of validity and recognition, yes, okay, it can be done by electronic message. Okay, and it is equivalent to using the conventional methods. And then we also, okay, before we go to next section later, let's have a look at another common law case. This is the rule, okay, discussing or requiring that acceptance must be communicated by whom? By the offeree, okay, the one who received the offer. Or let's say offeree cannot make it, he can authorize anyone, okay, meaning he give authority, any person authorized by him. So if the person doesn't have any authority, so even though there was communication, then it's not valid. Okay, it's not considered as a valid contract. This is what happened in the case of Powell and Lee, very old case, 1809. So Powell applied for the position of headmaster, and then he actually attended the interview, and then he really was hoping to get the post, okay, and then he got insider info. Okay, he was told by one of the school board members that he had been successful in his application, so he was happy. He thought he got the post, but later there was change of decision. Okay, because it wasn't finalized yet. So meaning that here the information that he got was premature. So the board, however, changed its mind, and actually he wasn't successful later. So the board appointed another person, okay, another interviewee to the position. So Powell was angry because he thought there was a contract. Okay, he thought there was acceptance. But the court held that the passing of information, okay, when the information was conveyed to him by one of the board members, actually it doesn't amount to acceptance. Because why? The board member doesn't have the authority. It's like leak of information lah here. Okay, so it wasn't, that board member wasn't authorized, okay, to inform. Okay, it's too premature. It's not finalized yet. The decision. So the individual board member had acted prematurely and without authority. So there's no contract. There was offer, but there's no acceptance, okay, on the part of board members, okay, the interviewer. So no contract between them.
Doctor, I have a question.
Yes.
So what if can you hear my voice?
Yeah, I can hear you.
Okay.
I want to
earlier,
yeah, okay.
I'm not turning on my camera. Can you see me?
Let's see.
Okay,
yeah,
so acceptance can be accepted by the offeree or the authority, but what if there is miscommunication between the offeree and the authority? So will the contract
be no contract. It has to be absolute, it has to be clear. If there is any misinformation, as if there's no contract, it has to be very clear. That's why it has to be communicated clearly, expressively, accepting all the terms. If new term, okay, is detected, so it's not absolute anymore. Problem with the contract here. Good. Okay, thanks Nadra for asking.
Thank you, Doctor.
Okay, let's move further. Okay, we come to another subtopic. Sorry. Communication of acceptance. In what way, okay, acceptance can be communicated? So we have three categories, three kinds or three types here. The first one, okay, I think which is very common, okay, typical modes of acceptance here, typical way of communicating, instantaneous means. Meaning offeror makes the offer to the offeree instantaneously and asking for instantaneous response as well. Okay, and then another rule that we are going to learn today, even though maybe nowadays it's not that significant, but the rule stands as it is. Okay, it is still a good law today. Okay, postal acceptance rule, because the rule is quite unique, so we have to learn it. And then also we are going to discuss email or whatever rules pertaining to e-commerce. Okay, we don't categorize together email and instantaneous means, okay, because sometimes email is not really instantaneous, so there could be some variations to it. That's why we put into three separate categories here. Okay, the first one, this is actually the auto design kan, so I just click, just choose, so it has the picture there, so you just ignore. I don't know, is it demon? No kan, it's not demon kan. Right, so acceptance by instantaneous means of communication. Okay, here what's the meaning of the word instantaneous means of communication here? Actually it refers to immediate communication, mean that here it is done immediately and it is actually similar or exactly the same, yeah, akin to the face-to-face communication. So as if you are face-to-face with each other. For example, telephone call. Okay, even though you're not face-to-face, but as if the effect of communication is very, very instant. Meaning that you ask and then the other party respond. Okay, because you are talking to each other through telephone. And what more if it is video call? Okay, nowadays usually we tend to have video call. So what's the rule governing instantaneous means of communication? Acceptance is communicated, okay, when it is actually brought to the notice of the proposer, the one who proposed, the one who makes offer. The moment it is being communicated to him or her and he or she is aware about it, then yes, that's a contract. Communication is considered as completed. So example of instantaneous mean here, it will include telephone. Okay, I mean even WhatsApp call also considered as like telephone, isn't it? Okay, and telex those days, and facsimile. Okay, nowadays we still use facsimile. That one is by way of document. I mean something in writing, black and white. Okay, facsimile. The moment you send the fax to the other party, okay, the recipient will receive, okay, the document. Fax. That's I mean that's how it operates for fax. Okay, so the rule, okay, for instantaneous mean here is that communication using instantaneous mean is complete when and where it is received, not when and where it is sent, especially whenever it involves two different locality, two different destination, two different states or two different countries, okay? So when and where it is received, meaning that just sent from another country, received in another country, obviously. So this is what happened in the case of, this is a landmark case, okay? If you read any English law notes or textbook, you will come across this case. Antaurus, I'm not sure how to spell it, how to pronounce it. I think Antaurus kan, or is it Antaurus? Okay, Antaurus Limited and Miles Far East Corporation, judgment by Court of Appeal. So quite high weightage here. What happened between the two parties here? That's the picture of teleprinter. Picture of telex. Okay, an offer was sent by telex from London. London to where? London to Amsterdam. We have been in London before. Okay, maybe you have a holiday with your family in London. Maybe you were born in London. Okay, who knows? I was in London for a few times lah, because when I did my PhD, it was in Nottingham. So Nottingham, middle part of UK. London is toward the south. Okay, so quite a number of times I went to London. Missing London a lot. So we cannot travel now. Okay, so offer was sent by telex from London to Amsterdam, and then acceptance, okay, was sent also by telex, okay, from Amsterdam to London. And then as far as the modes or the methods of communication is concerned, okay, telex service is considered as instantaneous means of communication, instant, okay, instant. But how it operates, I'm not sure whether nowadays we still use telex, maybe, okay. It enables a message, okay, to be dispatched by a teleprinter in the picture, okay, teleprinter operated like a typewriter. I think it's like a fax, more or less, in one country, and almost instantaneously receive and type in another. Or you have to type. If fax, then you just, it's like photostat, Xerox, okay, the whole document. But here you have to type. For example, I accept your offer, you type, and then instantaneously the other party will receive exactly the wording, okay, the one that the sender type. Okay, now what happened? Okay, what's the problem with this case? Plaintiff wished to claim damages against defendant, okay, for breach of contract, and wished to start, okay, how to file a claim, how to start the action. So he wanted to start the action in London. Yes, he could do so provided the contract was concluded in London. Okay, now what's the issue? The court has to determine, okay, has to decide when was acceptance completed and where was the contract made. Okay, then only that will be the place, okay, to file a case lah, okay, or to start the case, to bring an action. So the court held that communication of acceptance was completed in London, okay, where the proposer received it. Okay, because proposer, the one who makes the proposal was in London. So he received it in his place in London. So that's why, yes, the contract was made in London. that is at the place where the acceptance was received. Because in this case, the one the offeree, okay, was arguing, actually we are the one who stand, okay, from Amsterdam. So actually the jurisdiction fall under Amsterdam. Okay, it always a problem whenever it involves two countries. Okay, like this lah. We have to choose the jurisdiction. Okay, the correct one. Cannot be lax of jurisdiction. So we have similar case. Okay, Brinkhaven Limited and Haxtell, 1982, and this is very high weightage of decision, House of Law. Okay, decision or observation by House of Law. So it's highly persuasive here in Malaysia, even though we have Contracts Act. So in this case, House of Law confirmed the rule in Antaurus. So Antaurus was decided in the year 1955. So it was later confirmed by House of Law in the year 1982, almost 30 years later. What happened here? Buyers had communicated their acceptance by sending a telex from London to the sellers in Vienna. Okay? And later, buyers, okay, wanted to file a claim. So buyers issued a writ in London. Remember, they are the one who accepted. Okay, they send the acceptance from London to Vienna. So buyer issued a writ. A writ is actually usually court's order lah, basically. Okay, you can have a look at the definition here. So so buyers were claiming damages for breach of contract, but the court held that the problem is that the contract was concluded in Vienna. It wasn't concluded in London. Okay, so here it wasn't properly done, the filing here. The court cannot proceed. Okay, the case cannot proceed in London. So the court set aside the writ of service for one of decision, lapse of decision. The court doesn't have jurisdiction, authority to hear the case. It has to be properly filed in Vienna rather than London. How to do it? Go and find counsel lah in Vienna or whatever. Okay. So and then the case is important, okay, because of this. That's the rule, okay, confirming the earlier rule, and the court actually expand it further. Okay, the court, make it very clear. Okay, the court observed that if you read textbook, okay, it covers these variations. What's the meaning of the word variations? The court observed that the rule, okay, the rule that acceptance is made when and where it was received, this rule actually will not cover all the many variations that may occur, especially if the parties were using telex. Okay, some of the variations that the court highlighted, for example, what if the message was sent out of office hour? What if the message was sent but no one in the office? What if the message was sent and then there was some problem and it cannot be typed or it cannot be received properly? Some words of missing, for example. So many variations here. So we can't really apply the rule strictly in all situations. We have to see what's the current practice, okay, in that particular, in commercial world, okay, and then we also have to consider who actually bears more risk, okay, here. Okay, so many things that the court will look into. Okay, but sometimes the case is straightforward, then just apply the rule. Whenever the case is not straightforward, okay, it falls under many variations, then the court have to look further to see whether there's a contract or not, whether there's a breach or not, for example. Okay, now we go to, again, now we are talking about contract entered into by electronic means. Okay, nowadays, everything was done, we have the word E, kan? E means electronic, basically. Or nowadays, because internet age, kan? Right, so there is a widespread use, okay, rampant use of electronic means, obviously, and whatever being sold on the websites. Okay, so now what's the issue? What's the legal issue now? Okay, it raises the question of we want to know whether the contract was valid or not, and when the contract was concluded. Okay, remember, whatever advertisement you see, most of the time it is not an offer yet. Okay, even though a public might think, oh, this is offer, I can accept straight away. That is not always the case all the time. Okay, so again, that's why we need the one that we discussed just now. Okay, Malaysian Electronic Commerce Act 2006. So meaning that here this e-commerce started 2006 or even earlier. That's why the statute, okay, was passed in that year 2006. Okay, so it provides or it covers or it is meant to cater for contracts entered into by electronic means. And just now, I mean, this is some of the relevant section. Okay, section 2, it says that it is applicable to any commercial transaction conducted through electronic means. Actually, this act, we read together with our Contracts Act 1950. Okay, here, because why? Contracts Act is very ancient, okay, very old. So we need some other laws to supplement, to be read together. So we read together. Whatever rule, principle in Contracts Act, it is still valid, but we need another act, okay, to supplement, to cover, for example, okay, what happened to transaction conducted through electronic means, electronic methods or ways here. Section 3, it talk about inference, okay, we infer the consent, okay. And then section 7, okay, we did already. Section 8, all right, it talk about the application of law. And we also have section 20 and 21. Okay, section 20 talk about time of dispatch. Okay, what is the valid time here? We want to know, okay, the time of sending, okay, time of dispatch. So it is deemed, okay, the court will infer, will presume it is deemed sent when it enters an information processing system outside the control of the originator. For example, we click submit or we click send, for example. Then it is deemed sent from that moment of time because it enters into information processing system of whatever database or whatever stream whatsoever, which is not visible, but it happened. I mean, it's there. Okay, time of receipt. So here we want to know, okay, at a point of time, the other party received the message here, okay, the electronic message here. So basically, there are two possibilities here. Okay, first, where the addressee has designated an information processing system, okay, when the electronic message enter the information processing system. It depends, okay, on the two possible situation here, okay, A and B, all right. And but most of the time, okay, B would prevail, okay, even though there is an option here, okay, when the electronic message comes to the knowledge of the address. Usually, the court will require the other party is aware of the message lah, of the receipt of the message. Because if not, it's always a matter of debate or argument in the court, because the other party will assert, okay, that I wasn't aware, I didn't receive whatsoever. Okay, so it's always a matter of argument and you have to prove it in the court. And place of dispatch. From where? From which place? Okay, it's deemed sent from the originator's place of business. Okay, whenever it involves something which is formal, okay, official, then place of business, office lah, usually registered office. And then place of receipt, okay, is deemed received at addressee's place of business. Okay, if there are more than one place of business, then the registered one or maybe the headquarters, principal one. Okay, let's have a look at the case. I remember giving you the case for your reading. I know it's very long, so sorry about it. Actually, the relevant part is not that long. Okay, only 1 or 2 paragraph kan, which is related to our topic here. But if you read the case, I think it's quite interesting kan, the case. It might happen. It happened in Singapore, so it was a well-known case actually. But it's also applicable here in Malaysia. I mean, it's very persuasive, okay, because the rule is similar. So the case is Chui Kin Kiong and Digiland Mall.com Private Limited, reported in 2004, and then the decision by Court of Appeal of Singapore. What happened was that Digilandmall.com, okay, it was an online IT company. And then one of the employee made a mistake with regards to the price. Okay, he was working with, he was a trainee, I think, working with the training sheet and then certain document, and then change the whole thing on the website. The price, okay, the price is listed as 66, okay, instead of 3,850. You can see the difference there, as if how many percent? Okay, I mean, you just pay a little, you get something which is very expensive. Okay, and this error, okay, wasn't or this mistake, it wasn't noticed by the company until the next day. It happened in the afternoon. Okay, the next day, the morning next day, I think they realized about it when somebody called and asked, "Is it true the price is so cheap?" Okay, so there, and by that time they realized about it. Okay, there were 4,000 printers ordered already. Okay, and it was ordered by not many people actually. And among the orders, it was done by these 6 people who brought this case to the court. Okay, they want to enforce the contract. Whereas this Digiland.com said, no, there's no contract. Because why? There was a mistake, and then we never intend to sell. It's not an offer from us. Okay, so that's basically what happened. And if you read the reports, the court go into detail. Okay, we want to know what's the mind, of the party when they made the offer. Okay, were they aware that actually it was a mistake? So the case actually more about mistake, which is your topic for next semester. Okay, not really this semester. This is vitiating factor which might vitiate, which might weaken the consent to the contract. So as far as our topic is concerned, we don't want to discuss about mistake. This is actually the screenshot from the case. So the issue which is relevant for our discussion is that we have 3 minutes more. When was the contract for the sale and purchase of commercial printers concluded? So we want to know at what point of time there was a contract. Is it possible to have a valid and concluded contract by using website here? Okay, because why? It was done automatically. I mean, the advertisement about the price on the website, ITT, no problem. And then the appellant, the 6 appellants here wanted to buy, place 100 orders, because they know this is an price basically. So they place a very high order, and then automatically the automatic system said accepted basically. That's why they brought the case to the court. They said, oh, there's a contract, so please honor the contract, otherwise you are in breach. But the company said, no, there's no contract at all. So the court held that High Court, before the case was brought to Court of Appeal, there was a binding contract between the parties, and contracts can be effectively concluded over the internet, and that program computers sending out automated responses can bind the sender. But after this, High Court actually go into details actually, even though it's possible to have contract concluded by way of online website here, but eventually there's no contract, there's no valid contract. Okay, because why? There was a mistake to the price, and which was fundamental. It goes to the root of the contract. And then the most important part is no consensus ad idem. Remember when we discussed, it must be meeting of mind. Meaning here, offeror want to sell this and you are buying that. So here, offeror doesn't want to sell this thing at this price. So there's no consensus ad idem. This is an exceptional case actually, because the unique facts here, I think it will be different if, for example, only normal buyer want to buy 1 or 2 each. Here you order 200, 300 printers, because you know it was a mistake. Obviously, that's why you made a mass order here. All right, we stop here. This is another case actually involving website as well. Or maybe last case. Bear with me before we stop here. The last case for today, eBay. This is a case from Australia, decision by Federal Court of Australia. eBay is quite famous, but not in Malaysia, not so famous because we usually use Shopee rather than eBay. I remember when I was in UK those days. Those days mean the year 2007 and then 2009 until 2011. Those days. So eBay, I use eBay almost every day. Use eBay because you can. It's like Shopee, you can buy almost everything on eBay and very, very cheap. I mean, the offer is very competitive. So here it involves eBay International AG and Creative Festival Entertainment Property Limited. It involves festival tickets. This is very hot festival. Everybody wants to attend this festival. So the tickets is so hot, not really hot. I mean, everybody wants to buy the ticket. Limited. So purchase online incorporated anti-scalping. Meaning that here, if you buy this ticket, you cannot really resell. You cannot really buy mass purchase whatsoever. And then the issue which is relevant to us, actually there are many issues, but relevant to us here, the court had to consider when contracts for the sale and purchase of tickets on the website were concluded, because it involves many clicking. When you click that you buy, and actually the conditions come later. Conditions of anti-scalping. Anti-scalping is like touting you are buying but you want to resell at higher price, which is not allowed because of the exclusivity of this festival ticket. So the court held that we want to know when the contract was concluded, whether the conditions actually were included or not here. The contract was signed and completed after the payment and nominated purchaser details were accepted by the other party. So it comes together with the conditions, condition of anti-scalping here. And it goes back to, actually, it is about effects of electronic I agree, or we call it click wrap agreement. When you click I agree, what's the legal implication? I mean, are you bound with all the terms that you said I agree, even though maybe you skip or maybe you didn't read can through? All right. So again, the legal issue here, all right, whether clicking an acknowledgement, I agree or whatsoever, yes or whatsoever, okay, on an online form, I think we do it, okay, many times, okay, most of the time. Whether is it similar? Is it akin to a fixing as if we sign the normal manual contract, okay, the printed one, the hard copy one, okay? Or can we equate with acceptance by conduct? You click I agree, so you show your conduct that you agree to all the terms, okay, and the contract was concluded. Usually it's always the issue, and most of the time it is in affirmative. Yes lah, basically. And there's also imposition of we call it constructive knowledge. You cannot say, oh, I didn't read, I didn't know about the terms. Cannot. If you click I agree, that's your conduct, your act, your performance, meaning that here you accept all the rules. Okay, when you click, so meaning that here you accept all the rules lah. You are bound by the rules. All right. Okay. All right. We stop here. Okay, I stop share. Okay, sorry, 3 minutes extra. So I stop record as well. All right. So we are going